My name is Michael Young, and I'm a lawyer who handles will contests and other contested estates in Texas. A very common legal ground for contesting a will is that the testator lacked sufficient mental capacity to execute the will. The legal term is testamentary capacity. What's the primary evidence that somebody lacked testamentary capacity? Where do you get that evidence? It's a common issue that I have in my cases and common issue that I discuss with my clients. Well, they come from two sources. First of all, medical records. Medical records will often note cognitive problems. And some records will just note alert or aware. Those are not necessarily all that helpful, but often, particularly when somebody is having trouble with cognitive issues, executive functioning, or showing signs of dementia or senility or whatever the term is, those will be noted in the medical records. And then if it's bad enough, the general practitioner will often send somebody for cognitive testing to get an idea of the progression, how severe it is, whether there's medications that should be taken. And in numerous cases, those can be very important. Even if they don't have a formal diagnosis of dementia, there'll often be notes of, patient complains of forgetfulness, or a child brings the parent in or grandparent into the doctor and says, hey, they're just not remembering things anymore. They can't drive very well. They're forgetting names. They can't manage their business affairs. They can't participate in the weekly backgammon or Scrabble games that they used to participate in, or the poker games with their friends, bunco, whatever it is. Those would be the types of issues that people have, and which they may confide in with the doctor or the family member might. And then you can take those medical records, and they're very good evidence, and you can hire a medical expert to actually testify to a jury specifically what those medical records mean and how they impact someone's capacity to understand the making of a will or the signing of a deed. The other area is just simply witness observations. Those of us who are not doctors may not be able to use the medical terms or to summarize medical records or explain fancy concepts of cognitive testing, but we can make our observations, particularly if we know someone fairly well. If we've known someone for years or for decades even, and we notice that they just can't function. They're not able to do the things I just talked about a few minutes ago, whether that's play cards, drive around town, they get lost, they can't explain certain things that they're doing, they have trouble remembering names and places. Those would be the classic symptoms, and that's very powerful evidence. Evidence, whether it's in the form of affidavits or testimony in depositions or trial, of someone who observed, has firsthand indications of the person. They're just not acting the same. Maybe they don't dress the same. They don't have hygiene like they used to. And sometimes I'll have cases, and this tells you about social media these days, where the opposing party, maybe someone who's benefiting from a will post things on social media, like one that I had in a case, posting on Facebook, when my aunt can't remember what day it is or what she had for breakfast. Now, this person was the beneficiary of a will that we were challenging. Okay, that's pretty powerful, and I'm surprised by what people post on social media even to this day, and I shouldn't be. But once again, that can be powerful evidence. Social media commentary, texts. I've had proponents of a will, someone who's the beneficiary of a will, text other people in the family about how this older person is senile. He's forgetful. He can't remember things. Well, that's going to be notable to a jury when that same person testifies in front of a jury under oath that, oh, no, he or she was fine, perfectly fine, and yet they have these text messages or they have these social media posts. That kind of stuff, that evidence is prime in a will contest. If you're involved in a will contest, feel free to give me a call.